draft Digital Markets Competition and Consumers Act 2024 Alternative Dispute Resolution Conferral of Functions Regulations 2026.
Is it the wish of the committee that the instruments be debated together? Okay. I will now call the Minister to move the first motion and speak to both of the instruments. At the end of the debate, I'll put a question on the first motion, then ask the Minister to move the second motion formally. I call the Minister to move the first motion. Minister.
Thank you, Chair, and good afternoon. It's a pleasure to serve under your chairship. I beg to move that two instruments, the Digital Markets Competition and Consumers Act 2024, Alternative Dispute Resolution, Conferral of Functions Regulations 2026, and the Digital Markets Competition and Consumers Act 2024, Alternative Dispute Resolution Consequential Amendments Regulations 2026, which were laid in draft before this House on the 26th of January 2026, be approved. These instruments relate to the ADR chapter in the Digital Markets Competition and Consumers Act 24, which received royal assent in May 2024. The Act repeals the Alternative Dispute Resolution for Consumer Disputes Regulations 2015 and replaces it with a strengthened framework in Chapter 4, Part 4 of the Act. In most instances, disputes between consumers and businesses can be resolved without the need for any formal action. But when consumers and the trader cannot come to a solution, ADR is an effective means to secure redress for the consumer without resorting to litigation. All ADR providers are independent third parties offering dispute resolution that is usually less confrontational to the consumers and businesses involved. But not all ADR providers have the same accreditations and standards, so consumers can experience inconsistent quality of services. For ADR to be effective, it must be of high quality and meet certain standards. The Act aims to strengthen the quality of ADR available to consumers through numerous things, by introducing a mandatory accreditation framework for ADR providers for consumer contract disputes, providing a robust set of accreditation criteria to ascertain ADR providers' expertise, transparency, independence and accessibility prior to being accredited, providing ongoing monitoring and review to ensure that accredited ADR providers continue to meet those high standards. The Act includes the power to revoke or suspend accreditation, limit accreditation or impose further conditions if a provider is found to be non-compliant. The intention of mandating accreditation of ADR providers is to strengthen the ADR framework in the UK. Government believes these changes will help deliver a trustworthy, timely and fair service that consumers and businesses can trust to resolve consumer disputes with improved oversight to monitor standards and ensure consistency. Section 307 of the Act allows certain ADR functions to be conferred on another person. The Digital Markets Competition and Consumers Act 24, Regulations 2026, confers on the Chartered Trading Standards Institute, CTSI, responsibility for managing the provision of ADR in consumer contract disputes in non-regulated sectors, including the functions of accreditation, monitoring and reporting on the operation and effectiveness of ADR provision. This includes upholding the standards of ADR providers in the UK through powers to compel or sanction ADR providers to improve performance in the event that they do not meet their obligations. It also requires the CTSI to prepare quarterly and annual reports for the Secretary of State at the Department for Business and Trade. The reports will contain information and metrics on the performance of the CTSI, ADR providers and the ADR landscape in the UK to ensure accountability and transparency, and enable the Secretary of State to maintain oversight of the operation of the system of accreditation and the provision and quality of ADR carried out in the UK. The decision to confer these functions on the CTSI has been taken in recognition of their authority, track record and expertise in this area, including their long-standing and constructive relationships with ADR providers. Separately, the Digital Markets Competition and Consumers Act 2024 Regulations 2026 make amendments to primary and secondary legislation in consequence of Chapter 4, Part 4 of the Act coming into force, and the revocation of the ADR for Consumer Disputes Regulations 2015. The consequential amendments deal with redundant references to the 2015 ADR regulations and in some cases replace them with a reference to Part 4, Chapter 4 of the Act. These amendments do not materially change the policy or effect of the underlying law, they simply keep the statute book up to date in the usual way. As I hope is clear from my remarks, the intention of both of these regulations is to support and strengthen the ADR framework in the UK. They will put it on a stronger footing that provides a consistent, trustworthy, timely and fair service that consumers and businesses can trust to resolve disputes amicably with improved oversight to monitor service standards. I invite the House to support the passage of these instruments and commend these regulations to the House.
The question is that the committee has considered the draft Digital Markets, Competition and Consumers Act 2024, Alternative Dispute Resolution, Conferral of Functions Regulations 2026. Opposition spokesperson, Gareth Davies.
Well, thank you very much. It's always a great pleasure to see you. It's a great pleasure to see Honourable Lady also. Alternative Dispute Resolution, or ADR, is intended to provide a low-cost, efficient alternative for resolving disputes between consumers and businesses. And I thank the Minister for setting out today what these regulations are seeking to achieve. The regulations before us follow various pieces of work that have been carried out by both the Conservative government and the Labour government over many years, ultimately with the overall goal of securing a fair deal for consumers and a fair operating environment for businesses. While the opposition remains supportive, of course, of the broad goals of the Digital Markets, Competition and Consumers Act of 2024, we in this place should always be mindful of the adverse impacts of introducing any kind of red tape upon British businesses, no matter how well intentioned it is. And so to that end, as you'd expect as the official opposition, I do have just a few questions to probe some of the elements of the measures that have been introduced today. Firstly, I'd be grateful if the Minister could set out the status of the ADR provider sector currently, and how the government sees the sector changing as a direct result of these regulations. More specifically, can I ask how many ADR providers there are in the UK today, and how many of these are currently unaccredited, and therefore how many will be impacted by the measures that we'll be voting on in a moment? Does the government expect the number of ADRs that she will tell me to reduce as a result of the requirement to seek accreditation? And if she does, what impact does she believe a reduction in the number of ADR providers will have on consumers and on businesses who use these services? And finally, I'd be grateful if she could provide the government's view on the impact of these regulations on those who operate the actual ADR businesses themselves. I've read the explanatory memorandum, and it sets out that the government expects there to be no impact on businesses. In fact, it says the instrument does not impose regulatory obligations, but that's exactly what we're doing today, and so that looks like an error, and I'd be grateful if she could clarify whether that is indeed an error or just explain the language in the explanatory memorandum for the benefit of the committee. Thank you.
Minister.
Thank you, Chair, and I thank the Shadow Minister for his comments and, of course, support for the Act in front of us today and the legislation we are considering. The CTSI's role regulations place, obviously, the CTSI on a statutory footing, and I've alluded to in my introductory remarks the role of the Secretary of State and the accreditation determinations, monitoring and enforcement and information sharing under the Act to the CTSI, as well as the mandatory and accreditation requirements. In terms of exempt ADR providers, to avoid duplicated regulatory provision, the Act exempts ADR provision under several ombudsman and equivalent schemes which are already regulated under other legislation. These are either statutory bodies performing statutory functions or redress schemes regulated by other bodies and under other legislation. So if a sector already has its own dispute resolution system, these new ADR rules won't apply, and that avoids doubling up regulations and makes sure businesses follow only one set of rules with no confusion about who is responsible. There are also some statutory bodies which, to an extent they do carry out ADR, and it is not considered appropriate to regulate as their remit does not cover consumer contracts as defined in Part 4, Chapter 4 of the DNCCA. To his point around the specifics on the statistics, be happy to follow that up afterwards if he requires any further information. In terms of the effect of Schedule 25 listing those exempt ADR providers, that is quite clear, but again, if he would like further information on how we are avoiding duplication, we'll be happy to provide that, as there is a power to add further exemptions in the future, which might be used where it is more appropriate to regulate ADR elsewhere. What's really important about this legislation here in front of us today is how it will make sure that ADR is much easier for consumers and for businesses, and I think that's really important to reflect on. The significant cases that ADR can provide in terms of support and streamlining for businesses and consumers is significant, and it will offer that cheaper and faster alternative for consumers and businesses seeking to resolve disputes in comparison to making a claim to the court. And this framework gives us flexibility, I think, to update those standards over time, which is really important, and provides that foundation for considering further reforms if required. So yes,
Gareth Davies.
I'm very grateful. I totally understand she may not have the information to hand right now. Will she commit to writing to me with that information?
Minister.
Yes, sorry, I thought it was clear on that. I'd be happy to provide that follow-up information, and I will conclude that, Chair. Thank you.
The question is that the committee has considered the Digital Markets, Competition and Consumers Act 2024, Alternative Dispute Resolution, Conferral of Functions, Regulations 2026. As many are of that opinion, say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it.
Draft Digital Markets, Competition and Consumers Act 2024, Alternative Dispute Resolution, Consequential Amendments, Regulations 2026.
Minister to move formally.
Formally.
The question is that the committee has considered the draft Digital Markets, Competition and Consumers Act 2024, Alternative Dispute Resolution, Consequential Amendments, Regulations 2026. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order.